Here's a common question, and I will tell you there are some websites out there that have very inaccurate information. And honestly, as an attorney, I kind of find it a little bit upsetting. It's a scare tactic. There are some states where perhaps your license would go under suspension immediately. Maine is not one of them. When you're arrested for OUI, there's a process. The officer has to compile a police report. He's got to send a copy of that report to the Bureau of Motor Vehicles. A copy goes to the district attorney's office. The Bureau of Motor Vehicles has to review the report for sufficiency of information and to believe there's probable cause. Then they've got to generate a notice and send it to you. That notice places you on notice that your license will go under suspension, or if you're not from the state of Maine, your right to drive, and that you have a right to a hearing. It is not automatic. Yes, you will go under suspension at some point, but the length of time can really vary. We could be talking 4 to 6 weeks before you get that letter. It could be longer than that. It could be shorter than that. It's really based on how backed up or not the Bureau of Motor Vehicles is. But it is not automatic, meaning you don't go under suspension that night because you were arrested and charged with OUI. That is not how it works in Maine. So if you've seen that on someone's website, that is inaccurate information. Here's a question I get asked fairly frequently. Is there some type of temporary license or Cinderella license that I can get because I've been charged with an OUI and later suspended? I don't know how it works in other states, and it sounds like there are these other options. In Maine, there are very few options. If you're charged with an OUI, you have a right to a hearing at the Bureau of Motor Vehicle level. You get to contest the case at the criminal level. But if you're suspended by the Bureau of Motor Vehicles following a hearing, there are very few licensing options. One of them is a work-restricted license. You can immediately apply for that work-restricted license at any time, and it's not a guarantee. Someone has to review it, and it's discretionary, so they may grant that work license application, or they may not. One of the sticky things about requesting a work-restricted license for people is they have to put down the name of their employer and their contact information, and the Bureau of Motor Vehicles will call the employer to verify that you're employed. So if you don't want your employer to find out, you may not want to apply for a work license. You can also apply for an ignition interlock device. That's an entirely different process. You've got to complete some steps like the driver education evaluation program. Perhaps there may be additional counseling. And you've got to spend a period of time with no privileges whatsoever before you be eligible for that IID or ignition interlock device. If you're convicted in criminal court, there is not a work-restricted license privilege like there is with the Bureau of Motor Vehicles. And based on what you choose, if you're suspended at the Bureau of Motor Vehicles, for licensing options may affect how the court-imposed suspension will impact you. And it's important to talk about the interplay between those different licensing options between the BMV and the criminal case with your attorney to have a full understanding of the options available and what suits you best for your particular situation. In order to get the ignition interlock device installed on your car, you've got to meet a couple criteria. Or number one, you have to serve at least 30 days with no driving privileges whatsoever. Number two, you must complete all of your DEEP, the Driver Education Evaluation Program, all of your DEEP requirements. If you've completed all of your DEEP requirements, you've served at least 30 days with no privileges. On day 31, assuming that's a weekday, you get the ignition interlock device installed on your car. Once it's installed, the installer will give you a certificate of installation. You bring that paperwork as proof to the Bureau of Motor Vehicles. They then reinstate your license conditionally, which means the condition is you may only operate or drive a motor vehicle, i.e. your car, truck, motorcycle, with an ignition interlock device in place. That means if you have your two-car family, if you want to drive both cars need the IID. Otherwise, you're restricted to driving a single car with that IID in place. If you were to be convicted on a second offense OUI, some of the things that are available to you early on a first offense are not available to you. You're looking at a 3-year loss of license, for example. Whether you're suspended by the Bureau of Motor Vehicles or convicted in criminal court, it's a 3-year loss of license. So let me give you a hypothetical. Let's just say, because the standard of proof at the Bureau of Motor Vehicles is very low, preponderance of the evidence. Let's just say that you had the hearing and you lost. Your license is now under suspension for 3 years. But you still have a very strong criminal defense case and the charges are reduced, or you go to trial and you're acquitted, meaning the jury comes back and says not guilty. Does that undo the 3-year loss of license to the Bureau of Motor Vehicles? The answer to that is no. So the only way to reduce it at that point is with the installation of an ignition interlock device, and that will only reduce it from 3 years down to 9 months. Now, 9 months with no driving privileges is rough, let's be honest, but it's not as bad as 3 years. But here's the rub. When you're charged with a second offense OUI, if you want to avoid these significant license suspensions, you've got to win both sides of the equation. You got to win the Bureau of Motor Vehicle hearing, and you need to come out unscathed to the extent you can on the criminal case. Because if you're convicted in criminal court of a second offense OUI or even a first offense OUI, when you're facing second offense charges, Bureau of Motor Vehicles will impose a 3-year loss of license. My name is Attorney William Bly. If you've got questions about how an OUI is going to impact your ability to drive or your driver's license, just think of this. OUI, better call Bly.